Okay, let's pick this back up. This is the second part of the Judicial Branch, Chapter 19 PowerPoint. Again, we're going to try to go through this fairly quickly. As always, you can pause, rewind, but more importantly, if you have questions, please don't hesitate to write them down, and we can always discuss them in class, which I find rewarding that other kids might be able to help us answer these questions. We're going to pick this up as we talk about the district courts. If you look at the map right here, it's the map of the United States. At the district level, every single state, so you look at Arizona, there's just one district court. Forget about the different colors for right now, but there's just one district court for Arizona, as there is for Utah or Wyoming. If you look at Texas here, you might see some dotted lines. They have 1, 2, 3, 4, 5 district courts in one state because the state is so large. If you look at Illinois, we have 3 separate district courts, and that'll be important. Every district court is where the trial court begins. This is, oddly enough, the only court in which allows evidence, allows you the opportunity to confront your accusers. The government will need a lawyer there to represent the United States. And since this is the district court, that person is called the U.S. District Attorney. Here in Chicago, it is, well, let me just rephrase this. The district attorney used to be Fitzgerald. He's the person who put away Blagojevich. The defendant has a lawyer, and if they don't have one, it will be provided. Again, they're very busy, totally overwhelmed. If you can afford your own lawyer, I would highly suggest doing that. At this level, the judge or jury hears the case. There are 3 outcomes. You could be either guilty, you could be found innocent, you walk away, or in Blagojevich's first case, there was a hung jury on many of the counts, most of the counts, as a matter of fact. If there is a hung jury, the government can decide to retry them. I believe there was 25 counts originally for Blagojevich. There was a hung jury on many of them. One person voted to say he was innocent. So the government basically looked at what the jury said, and they came back with 16, I believe, counts on him the next time, and they found him guilty on those charges. After that, a couple of months go by, then there's a sentencing phase that only the guilty people have to go through. They're going to hear from both sides, and then the punishment is set. If you don't like the decision of the court, you can always appeal the decision to the appellate court. We've always heard that, and not a lot of people know what that means. Before we go to the appellate court, I'd like to draw your attention back here to the map up here. You see the light blue? That is the appellate region number 9. If you sue in district court in Idaho and you want to appeal it, you have to go all the way over here to San Francisco, which is where the appellate court sits. In the 7th region, which takes Wisconsin, Illinois, and Indiana, if you sue in the Indiana district, Southern District of Indiana, and you want to appeal it, you will have to go to Chicago, which is the home of the 7th appellate court. Hopefully that makes sense. So let's take a look at that. This is where a lot of people don't understand the court system. They always hear you want to appeal the court case, but if you do, you actually have to pose a question to the appellate court. This is not a court case that we're used to. No jury is involved. There is no new evidence brought in. There is no testimony here for the most part. If a case is to be appealed, the appellate must display a question. They have to show a mistake was made. For instance, was the instructions given by the judge to the jury, were they accurate? Were they confusing? Something along those lines. But there's always a question that these guys will look at. The appellate court has to hear the case. They have to hear the case. They hear over 31,000 court cases a year. And the appellate court does not retry the case, as I was just talking about. They will hear the arguments of both sides of the case and then decide if there really was a mistake. And then usually there's a panel of 3 judges. You could hear a case en banc, which means the entire appellate court judges, which tend to be 30 to 40, but that's kind of rare. In the end, the judges are going to agree with the lower court decision. They can send it back to correct a mistake, to say, Judge, fix this. Or what they can do is reverse the decision altogether, which is kind of interesting. And of course, if you don't like their decision, you can always appeal it to the Supreme Court. Obviously, what they say goes. It's the final spot that you can go to. And of course, we call it judicial review. Supreme Court gets about 1,000 or more appeals every year. Actually, I think it's 10,000. I think that's a typo. Each justice reads the briefs that are sent up to the court, and in reality, the clerks do. 8 of the 9 justices belong to what is called a cert pool, and they divide up all the appeals amongst the 8 and write a report, and then we'll pass them around the other 8. There's only one justice, Sam Alito, who does not join the cert pool and will read all 10,000 appeals. Very tedious thing. They have what is called a rule of 4. If 4 justices will vote to hear a case, the Supreme Court issues what is called a writ of certiorari. There's many ways of saying that word, certiorari. That's the way I say it, but when I was at a conference, I've heard 4 or 5 different ways of saying it. So there is a rule of 4, and you might think, why would they hear a case? If you look at the previous screen, if an appellate court in California says Obamacare is constitutional, but an appellate court in Florida says Obamacare is unconstitutional, you have 2 separate decisions basically over the same law. So it kind of forces the Supreme Court's hand. Oftentimes, if a decision is a question about the Constitution, they're more apt to hear the case. Again, they issue a writ of certiorari, which is basically a piece of paper that is sent to the 2 sides that says, send all the information to the Supreme Court, your briefs on your appeal. If there's less than 4, the lower court decision stands, whether it's the appellate or the district court decision. Once the case gets in front of the Supreme Court, this is basically how it works. Between, I guess it would be the last week of June is through maybe the 3rd week of September, maybe the 2nd week of September, the court does not meet. They're on summer recess. The first official day, they get back early and start discussing cases that they want to hear that year. But the first date is the first Monday in October, and it goes to late June. Again, the process, the briefs are sent to the court after they issue a writ of certiorari, which again, briefs are summaries of their argument, maybe 3 or 4 pages. At this time, they accept amicus briefs, which are briefs sent by friends of the court. If it was the Obamacare, you might have people like the Cato Institute, an interest group who like small government. They may send an amicus brief saying that they don't like Obamacare, and this is why. Then again, you might have the AMA, the American Medical Association, saying we do like it, and this is why. Again, 2 or 3 pages. There are oral arguments where both sides are grilled by the justices trying to poke holes in the lawyer's logic. Kind of talked about that in the U.S. versus Lopez case. And we talked about this as well when, in a case like U.S. versus Lopez, the U.S. needs a lawyer. That lawyer is called the Solicitor General. This is actually the front of an amicus brief that is signed by many scientists. in a case between the Commonwealth of Massachusetts versus the United States EPA. After oral arguments occur, they basically have during oral arguments, each side has a half hour to argue their case. The Supreme Court justices will ask questions. When the oral arguments are done, the Supreme Court conference every Wednesday and Friday afternoon, the justices, with no one else in the room, meet to discuss the case. The Chief Justice, of course, runs the case. They poll who and what are they voting for, and in the end, they vote. This is where the strict constructionist or the original constructionist of the Constitution, they have their views, and the loose constructionists have their views. And they're going to announce their decisions 3 to 4 months later. You might be thinking, why the heck does it take 3 to 4 months later? Because when they issue a decision, it tends to be fairly lengthy, and they want to agree on language. If not, someone will write their own, what they call, opinion. And there are 3 sets of opinions, and I hope this makes sense. So I try to water it down to hopefully it'll make sense. The majority opinion is basically the opinion of the majority of the justices. So, for instance, let's say a question was posed to the Supreme Court, and we heard arguments about who the best baseball team in Chicago is. Was it the Cubs or the Sox? The majority opinion, let's say, was the 7 justices say the Sox have a better team. 2 are going to issue what is called a dissenting opinion. They completely disagree. They think the Cubs are better. The majority opinion might say the Sox have a better pitching staff and a better defense, where the concurring opinion agrees that the Sox are better, but they believe in a different rationale. Maybe they feel like they have a better offense and they bunt better than the Cubs, which is why they're a better team. So you have a majority opinion, which is who they're siding with, a concurring opinion, which is they agree with who wins, but with a different rationale, and dissenting opinion basically disagrees completely. Most of the cases are unanimous as time has gone on, and those are usually dispensed with fairly quickly. As I want to go back a little bit, the ones that are issued late in the term in June are the ones that, like Obamacare, were very contentious, and they're having problems writing their opinions and getting a majority opinion. There are other terms that you might need to know, which is stare decisis, and that is a precedent to previous decisions of the court. Things like Roe versus Wade, which gives women the right to have an abortion in the first trimester. Right now, that is precedent. Normally, precedent is written in stone. To upset precedent is very rare. So precedent is important. And in activist judges, both sides are called activist judges, and basically an activist judge is making law from the bench. So laws technically should be passed through the legislature, but if a court passes a law by finding something unconstitutional, they may be seen as an activist judge. Okay? So that's kind of important as well. I do believe that is it. And again, I would reiterate, if you have any questions, rewind it, but write those questions down, and hopefully we can tackle them in class. I hope this made sense, and this correlates to your reading fairly well.